We're live.
Okay, good morning. We're back in the Judiciary, May 7th, back to H772 and the Alleged Council with this. Go through the new drafts. This draft that is what we discussed yesterday. And floor is ours.
For the record, Cameron Wood, Office of Legislative Counsel. Happy to walk through the next version of your amendment to 772. So this is going to be draft 4.1. Most of the changes here are going to be related to what's been removed and then what has been included in the study and the report coming back from the judiciary towards the end of the bill. A few quick things though I'll point out as we walk through. So one of the main changes to this version is removing all of the amendments to the section related to terminating a rental agreement. As we've talked about, a lot, you have to terminate the rental agreement, then you have to bring the ejectment action. Part of the changes that were being proposed by the House was a lot of changes to the termination of the rental agreement section, reducing some of the time frames, extending some of the time frames. This was the language that you all were talking about, whether it was criminal activity or illegal drug activity, that subsection. All of those time frames and language have been removed, and we've incorporated a lot of the review of that into that study, as I mentioned at the top. But because some of all that language was removed, I've made some other deletions throughout. So, for example, there was a definition of immediate family, because that was part of some of the changes that were made on the House side. Because we've removed the ability to terminate a rental agreement to allow your immediate family to move into the unit, we don't need a definition of immediate family anymore. So that's been removed. There are a lot of sections that still remain. So and I'll just briefly touch on them and keep going unless you have questions. There was the rent increase. This is a cap on a landlord not being able to increase rent more than once in a 12-month period, unless the landlord purchases the dwelling unit, in which case the landlord at that point could increase rent.
Cameron, just to clarify, that section is not something we made any changes to.
Correct. Yes, sir.
And that is an economic development committee question, that section. So we're going to leave it on that.
Next is the resident rental application, where you are adding a definition of what an application fee means. You're saying that the landlord cannot charge for an application fee. This is a reminder, you all reviewed earlier some language about credit and background checks.
And then once really, I don't want to be hypocritical here. That is, would that also be considered a economic development question? I feel like it might be.
I will leave that between you and of the other committee. It was related to credit and background checks.
Yeah.
And whether credit checks, background checks, etc., fall within the purview of this jurisdiction.
And the question was, do we allow a fee to be charged for that?
Right. If you remember, the section said that the landlord could charge for cost of the fee unless the tenant provided a copy, and then the copy had to be within 90 days.
Yeah. Sorry, this may be a last minute change.
No, that's okay.
My instinct is telling me that that is more so of an economic development question, because it's about credit checks. It is also about a background check. It's about also whether or not the person will be charged for something.
Yes.
That is something that I think would fall into economic development, and I don't want to cherry pick what I think is in our jurisdiction and not good. We could put that back in. We could have Senator Clarkson's committee address it however they want to.
The next section here is about security deposits. This would put into statute that the landlord cannot charge for more than 2 months of a security deposit, authorize the landlord to charge for a pet deposit. One of the things that I wanted to mention was here on page 4. And this is not highlighted because it was changed. It's highlighted because I wanted to mention an issue for you all to review. Part of the bill as it came over from the House was that there were shortening of termination risk periods for things like non-payment of rent and breach of the material terms of the rental agreement. That bill shortened the notice period to terminate the rental agreement under those scenarios. But the bill also extended out the notice period required for a no cause eviction to 90 days. And as part of that, extending that out to 90 days, the House proposal included this requirement that a landlord had to provide half of a security deposit back 45 days before the termination of the rental agreement. So halfway between the 90 days, you have to give half the deposit back. You've removed the 90-day notice period for those no cause terminations. So I'm not sure that this section really fits well within the current construct. And so I didn't want to remove it without explicit authorization from the committee, but I think it may not make sense at this point in time because I think these references are not going to fit the 4467D and E. And currently, if you go with the current statutory law for a no cause eviction, if you all remember, I talked about at the very beginning, it's going to depend on 2 questions. What if it is the risk in writing and has the person been in a unit for 2 years or longer? Because depending on the answer to those 2 questions, termination notice period could be 30 days, it could be 60 days, or it could be 90 days of the current statute. So,
Is there anybody opposed to removing this? Seems more of like a technical issue. So I'm fine with having to break it out for you.
okay, so then moving forward, just keeping in mind we have the G here we talked about last time. I've unhighlighted it because I think you all were comfortable with what we had, authorizing the municipalities to have a security deposit that could be less than 2 months' rent. Now we have the section about retaliatory conduct. Nothing has been changed here, but just as a quick reminder.
On the section about, and I apologize, this may have come before I got in the chair, but on the section about the limitation on not charging more than 2 months rent, is the language that we discussed still there about allowing cities to be more protective?
Yes,
Okay.
yes, that subsection G is still there.
Got it. Okay, thank you.
And so this section is about retaliatory conduct. A landlord, cannot retaliate against a tenant if the tenant does one of the things in this list here. And what was proposed from the House is to expand that list to include if the tenant has taken legal action authorized by law against the landlord or has contacted law enforcement in response to domestic abuse. That hasn't changed, so that's still there. Okay, so now we get into section 4467. This is about the termination notice periods that are required to terminate a rental agreement. So as I mentioned, I've removed all of the changes to this section, so we can keep it as the current law exists. But what has been kept are 2 provisions. The first one, which would now be B3, is about the Good Samaritan provisions here that a landlord cannot terminate the rental agreement because the tenant is subject to seeking medical assistance for a drug overdose, is the subject of a good faith medical request for a drug overdose, or is within close proximity of the scene of a drug overdose. And then the next piece is regarding the language that we've included that authorize a tenant to bifurcate the rental agreement if the tenant is the victim of domestic abuse, sexual assault, or violence. So that language that you all work through, that's here. So now before A and B, and then we still have the section about bifurcation of the rental agreement, where the tenant can request it, the landlord can authorize it. If there's a court order, then the landlord shall bifurcate the agreement at that point. So nothing has changed here. Just kind of quickly walk it through to make sure that you're aware of what's been removed. So now we get to the ejectment sections. So what has been kept here is a technical amendment in 4853A. Then when we get to, there was the expedited hearing was right here in the section. We've removed that because we've incorporated it down into the study, which I'm going to get to in just a second. So the only thing that remains here is section 4854, which allows the landlord to dispose of the tenant's property immediately upon being legally restored to possession of the unit, which is a change from the current law. Then we get to the trespass section. So I haven't made any changes to the trespass based on what we discussed yesterday. So you still have the inclusion of this new subdivision D, authorizing the no trespass when someone's been ejected, requiring the individualized consent, requiring that it's enforceable for 1 year. Those are the things that we discussed yesterday that haven't changed. Then the remainder of the bill, all the way till we get to the study, are the positive rental payment pilot program, the ability for the landlord to maintain or to keep a security deposit that's greater than 2 month rent if the agreement was entered into prior to the effective date of this bill. And then we get to technical training from CDOEO, providing to landlords and tenants. There was some funding on the House side to do this training. So now we get to the board study and report. And I've made some changes here, and you'll see the highlighted changes in these next few pages. So as a reminder, this is a report that would be due January 31st of 2027. And it's a report on the feasibility of implementing a dedicated housing docket, or excuse me, a dedicated docket for handling these matters. So what I've changed here is the first piece is looking at the financial costs of implementing this dedicated docket. The second is what are the workforce impacts of the dedicated housing docket? And I broke this out to add additional information that you requested. So the number of judges and staff necessary to resolve all ejectment actions statewide within 90 days following the filing of the complaint. 2, the judges and staff necessary to meet the timelines outlined in 12 VSA Chapter 169 for expedited hearings. There's already 2 expedited hearings that are built into the ejectment subchapter: rent escrow and report, unlawful occupant of the dwelling unit. So what are the staff necessary to make sure that you're meeting those timelines in those 2 sections? And then third, the staff and the judges that are necessary to resolve ejectment actions fraud due to the termination of a residential rental agreement under 9 VSA 4467B2. That's the section that we were discussing that talks about the criminal activity, the illegal drug activity, the acts of violence. That was the section where you had the expedited hearing built into the previous version of the bill. So to resolve ejectment actions due to those terminations within 21 days from the date of filing of the complaint. So that's taking your expedited hearing and putting it right here and saying, what is the staff and judges that you're going to need to be able to accomplish that?
And maybe get into it in a moment, but does that include contemplating the element of the damage to the property?
Let me get to that here on the next page. Yes, sir. So currently, before I get there, just keep going. The impact of other court staff with the implementation of a dedicated housing docket, and then the other 2 things we have here are same to what we've reviewed previously, whether the facilities have the capacity to do this and any other matter deemed relevant to the judiciary. So then I've added in 2 other subsections here, a B and a C, to clarify the information that you're seeking. The report shall include information on legal issues to consider and requiring an expedited hearing for ejectment actions brought due to termination of the residential rental agreement under B2, including how the court would determine, or how the court could determine that a tenant is an ongoing threat to the health and safety of others if that were to be a condition upon which an expedited ejectment hearing would be allowed. So if you remember, there was a lot of discussion about whether or not there needs to be one instance that threatens other people, whether there needs to be multiple instances, whether or not there should be an ongoing threat to individuals for the termination to be effective. And the expedited hearing language that came over from the House required that in order to have the expedited hearing, it had to be an ongoing threat to other individuals. And so this is intended, how I was drafting it up, was to say that the court needs to give you information on how the court would make a determination that a tenant is an ongoing threat if you wanted to have that as a condition for allowing an expedited hearing. Sub 2 here is at what point in the ejectment process the 21-day timeline for an expedited hearing should begin. Should the 21-day clock begin upon the filing of the complaint? Should it begin upon service of the complaint on the defendant? Should it begin upon the answer being filed? Those are questions that will then dictate how long the total expedited process would take.
I think, Cameron, regarding sub paragraph 2, where it says at what point in the ejectment process, my initial instinct is that the judiciary may say that's a policy decision. You, the legislature, can choose when that begins.
Yes, sir.
Would it make more sense to ask if there are any procedural challenges with beginning the ejectment process, filing of the complaint, or beginning of after a response has been filed?
Okay. Agreed. Yes, sir. I think you're spot on for doing it.
Committee, any issues with that?
Okay, then we get to sub 3. Are there any legal issues with including damage to the dwelling unit under 9 BSA 4467B subject to an expedited ejectment hearing, and how the court would determine that damage to the dwelling unit is a threat to the health and safety of others? Currently, damage to the dwelling unit is not included within that subdivision B2. So just trying to signal to the court that, are there any legal issues with including it? And if so, how is the court going to make a determination that damage to the dwelling unit would be a threat to other people?
I think we likely run into the same issue where we're saying, are there any legal issues with including damage to the dwelling unit? I would imagine the judiciary would say, talk to the lead counsel, they'll tell you their legal issues. But I do think they could answer the question of how the court would determine the damage to the dwelling is a threat to the health and safety of others. So I'm not sure what recommendation I would have right now, but committee, do you have any thoughts on this? Ledge counsel,
that very well may be their response. Yeah. I definitely think how they're going to make that determination is something that they could answer. My thought with the legal issues question was there was discussion about whether or not the damage to the dwelling unit was already kind of included or subsumed by the other conditions in that subdivision. Is damage to the dwelling unit not already criminal activity? We do not already make that case. And so my thought here was if you're adding it in, how is the court going to treat that distinction? But yeah, I think you're right. They may come back and say, we can't really opine on language that doesn't exist, and we'll provide, judicial opinions before there's a matter or case before the court. So it may be best to take it out at this point if you're wanting to just hone in on specifically what the court can provide you information on.
So taking out the phrase any legal issues and so on up until it says how the court would determine that damage to the dwelling unit is a threat to the health and safety of others,
Yes.
keeping in that second.
Yes, sir. That was my thing. That's what I made a note for.
Committee, any thoughts on that?
So it's part of it. We were just looking, of course, making a decision. What else is the policy quick? Back to what you got.
Yeah, and I think if we're keeping it to that second question, we're asking them how the court performs its analysis. That is where they could say, potentially raise, here are some issues, or here's how we could do it. Somewhat similar to the change that we made above. So,
Okay. Page 21 here, any legal issues with shortening the timeframes for the termination of a residential rental agreement? Again, you may run into a similar argument from them. And so I'm happy to take that out as well.
That seems like pure policy.
yeah,
So
yeah, I think. Would it make more sense to have it say, are there any procedural issues with shortening the timeframes in which the different filings and notices could be contradictory or redundant? And I know we encountered that a little bit here and there. I think there was one with the 90 days, one for no cause and the other for, I think, selling the building.
Yes, sir.
And so perhaps things like that, where the creation of these different timelines could create redundancies or things that just don't really make sense. So do you think it would make more sense if we were to just say, are there any procedural issues with shortening the timeframes as proposed earlier?
I think they may come back and say, my assumption is the judiciary may come back and say there shouldn't be any procedural issues or changes based on what the timeframes for the termination are, the termination of the rental agreement, because that all comes pre a judgment action. And so where my thought is, where I'm thinking is, whether the time frame for termination notice is 30, 60, or 90 days, whether you keep it all at 90, whether you reduce it all to 30, I don't know that the judiciary is going to have an opinion, or it's going to change how they would subsequently process the case when the ejectment action is filed.
I do. So, I mean, if they're going to come back and say, well, I don't want to speculate too much, but I mean, it could be useful if they were to say it's somewhat inconsequential for it, and it doesn't really make a difference. That could be useful as we revisit this next year, most likely, Senator.
I think it's a good change to swap out procedural.
And to your point, Mr. Jeremy, I'm back to say exactly that. It's a strictly policy decision, and it doesn't impact the actual ejectment process, depending on how you want to set the policy of what the termination of this period should be.
Okay, yeah, and I think if we're covering that actually, yeah, that's if we can move to that. Okay.
Lastly, in some discussion from the committee about wanting to make sure there's a balance of the interests of the parties here. Just in developing a report, the court administrator shall work to balance the needs of the interested parties and making recommendations, including a balancing of the rights of the tenants, the landlord's property interests, and the safety of other renters.
We made a small change at the end of that line 6, and the safety of other tenants and their neighbors. Maybe any issue with that change?
I don't know if the judiciary would have any issue with this language. They may very well come in and say it's not their role to balance the interests of the parties. They're kind of intended to be a neutral arbiter of the issue. But I think you all want to have some language in here recognizing that there are multiple interests at stake when you're talking about the ejectment meter, the tenant rights, the landlord's rights, and then the health and safety of other people. And so, conceivably, I could see the judiciary coming in and saying, if you want to know what it's going to take to prioritize these issues that, impact all three people, for the terminations under a B2, for example, because there's some sort of criminal activity, we can set up a docket that gets those done within the time frame we've outlined, but here's the cost it's going to take to do that. And we would set up the system to prioritize those cases, or here's how we would set up the system, to handle those matters in a more expedited process. So I think it's conceivable that they would look to this and incorporate their thoughts about how to set up a housing docket, but
I think, yeah, I would assume that in doing this work, they would contemplate a balance and take away the interest of all the parties. Though I do think, in the long, thinking more long term, when we get the report back, or whatever, whichever legislators are here getting the report back, if there is language showing that this was part of why the judiciary was developing the report, and they have an understanding, the genesis of this. I think that could be helpful for the future folks in the city. So I don't think it causes harm necessarily to have this in there. Open
100% agree.
open to other laws. That's. Yeah, okay. Good, thanks.
The only other change is a reduction from the September 1 effective date to July 1 effective date.
I had proposed that because I think earlier on, there were so many changes in this that we wanted to push this out a bit to make it a bit more feasible for all the different stakeholders to have a bit more time to ready for all these changes, but considering how much the bill has been winnowed down, I think we can stick with the original effective date, the July 1. Any questions or comments? So we will vote on this at around 10:30, and I do have a question for Pro Tem. In terms of procedure, we would vote this out, and would I then request to recommit it to economic development with the committee's report intact?
Yes.
Yeah. And that would be version 4.1, that would go to economic.
Exactly.
5.1.
I'm gonna make the change that we
Oh, right.
discussed.
Yeah, okay.
And then they'll be able to look at the original bill and what we did.
Okay.
I know you have not for that chance.
Yeah. Anything else? Anything else? Steve, Cameron?
No, sir.
Okay. Well, then I think, let me look at this real quick. Very good. So if you could, Emery, if you could send the Zoom link to Senator Matos, just to, and okay. And so committee, if you could please be back here at 10:30, so we can have a full committee, and we're going to vote on 4 different bills. So, yeah, we are